All right, we are live. It's Friday afternoon, and we are here on 866 again. And we're gonna pick up where we left off yesterday. I have it marked, I'm sure, incorrectly. How has it marked correctly?
I do.
Great. So committee will try to get as far as we can. It would be really nice if we got through the whole bill in this 2 hours. And if we can, that would be great. If not, then we'll pick it up on Tuesday. But we're just gonna, if we can give Jamie in the weekend, not on Saturday or Sunday, but
It's really
On the other weekend.
Super Bowl for you.
then we'll be able to have a draft come Tuesday. So did we end on page 13 or 14?
Ended on page 13.
Line 12?
Yes. See?
I had it after all. Didn't have it marked.
I'll head home for the weekend. Have a good one. All right. For the record, Damian Leonard from the Office of Legislative Counsel. Yes.
So section 2 on line 14 is a bit about the withholding, and I think it covers the area that we talked about with who's responsible for the withholding in the end. Is that, I mean, this sounds like it's fairly boilerplate, but
Yep. So, yeah, this is boilerplate language here regarding to withholding contributions as if they're as if it's Vermont income tax. If I remember correctly from my notes, Commissioner Bolio had a couple comments on tweaks that the commissioner thought would make sense in this section and the next one. I will include those in the next draft or just a comment to highlight that for the committee. Off the top of my head right now, I cannot remember exactly what the tweak was, but I think there was an additional cross-reference that the commissioner wanted to see in there. So that's something we can do.
yes, please. And does that apply also to number 3, on page 14, or is that going to be different because of employees?
I believe that that also applies to number 3 on page 14. Try to do a better job today of scrolling both documents side by side. So again, this is requiring self-employed individuals to make quarterly payments as if they're paying estimated tax payments. I believe the commissioner may have highlighted a tweak that he was looking for in this language as well, so I'll include that in the next draft.
Right, and then section D is the exemption for employers who have an approved private plan.
That's correct. And so an employer with an approved private plan pursuant to section 2060 shall not be required to withhold and pay contributions pursuant to this section. The tweak that we talked about here was making it clear that adding another subdivision to make it clear that employees are not liable for unpaid contributions because the responsibility lies with the employer, the same as with FICA at the federal level.
And we refer to such language as belts and suspenders at times, clarifying, sometimes there's a clarifying phrase to bolsters what we generally accepted as the interpretation. Is that a safe way of referring to belts and suspenders?
It is a safe way. It makes it doubly clear. So
Repetitive even. No, it's not repetitive, actually, and I take that back. I don't mean to make fun of it. It's not repetitive. It's doubly clear. It's just restating the interpretation.
yes,
Sorry, I'd be fully there for a second.
that's okay.
Section 2055 benefits. This is what we have been talking about since we picked up the bill. So that A is about the length of time, no more than 12 weeks over a 12-month period.
And number 2 is the bereavement. 2 out of the 12 weeks can be used for bereavement. These are policy decisions. So this is entirely a policy question here. If the committee wants to come back to it to discuss length of leave, that would be a policy question. It's not a legal question.
This, speaking belts and suspenders, I'm sorry, I didn't raise my hand this way. Representative Burrows had earlier raised the question about extending the time frame for bereavement.
That would be in a different section. Yep.
B is
Yeah, so
determination of the amount that we're proposing in this bill, which is 100% of an individual's average weekly earnings.
So B is again a policy question for the committee.
Yep.
The two points on here. The first is line 20, 100% of average weekly earnings. So that's really a question of what percentage of earnings would you want to replace? The second question here, if you want to address this, is what's your cap? We've set it at the state average weekly wage, which is $11.35 a week. It can really be anything the legislature wants it to be. Obviously, changing it up or down, same as with the percentage of wage replacement, just affects the finances and the uptake of the
wage is something that can be determined through the Department of Labor's statistics, or
it is determined every single year because both unemployment insurance and workers' compensation benefits are tied to that state average weekly wage for the maximums. So we calculate it every year for those, and this would just carry that into this program.
So it's determined once for the year, right? And then stays
Yep.
at that level.
It's determined once each year. I believe it's done on July 1 every year. And then we're done for July 1. And then after July 1, that new average weekly wage applies. So what you would see here is that the cap could change every July 1 for these wages. One thing, we don't include this in the bill. And part of that is because this is a 12-week benefit. So for workers' compensation, which could stretch out over years, depending on the injury, there's a cost of living adjustment made every year based on this adjustment. Unemployment insurance doesn't have it, but the max increases. So if you're up against the maximum benefit, your benefit may increase to the new maximum. And that's all that this would do. So just to make clear that there's not going to be a cost of living adjustment, but for an employee who is pushed up against the maximum weekly benefit, if they're going in that period, say from June to the end of July, their July benefits would be slightly higher based on the new maximum benefit. Does that make sense to everyone?
Mm-hmm.
Okay.
All right, so we're on the page, top of page 15. Letter C is basically saying that you can apply for intermittent leave, which would be in day 8 hour. Roughly, or what it's classified as 1/5 of the individual weekly benefit amount. So 1 day's worth, day increments you can ask for.
1 day increments, assuming that the average individual works 40 hours a week, 8 hours a day, which, the standard sort of work week, and we've just split it into those 1 day increments. This is administratively simpler than trying to do hourly increments or something like that.
And it's for serious illness, which in and of itself should say that,
right?
Like I can't have a heart attack on Friday, go back to work on Tuesday. Oh, I could have a heart attack on Friday, go back to work on Monday and apply for that 1 day of work. Because that was a serious injury.
Yeah, but what you're not going to be using this for is saying I'm going to take 2 hours because I had a 2-hour appointment related to my general health. That's what sick leave is for. This is for that serious illness where you're hospitalized, you're at risk of death, you're under continuing care of a medical professional.
Yes,
So if someone's going through chemo and they need to take half a day, would they have to take the full day?
This would pay out the benefits in 1-day increments, so.
Okay.
Yeah, I just got something in my eye. Okay. I have dry contact and a little bit of dust, so. It's a perfect mix, so just bear with me while I blink and probably tear up in a second. It's not because I'm touched by my own testimony.
All right, so section D is, it just allows the benefits to be paid as a wage replacement. And so I'm assuming that 472 and 472D are the PFLA sections.
Yeah, so this refers to 472 is the Vermont Parental and Family Leave Act. That's our existing family leave, parental leave law. 472D is the new safe leave law. So this allows you to use these benefits as wage replacement for safe leave. And then the other reference is to the Family and Medical Leave Act.
Right, so it's covering all of the unpaid leaves that we have PFLA and FMLA.
And it covers the new safe leave as well, in addition to those.
And then this is saying out loud that the receipt of these benefits paid pursuant to this chapter shall not extend the leave provided pursuant to those sections. And is leave defined, is the word leave equivalent to job protected leave?
That's the intent. So the intent here, and this is another example of belts and suspenders language because we reiterate this in each of those laws. Obviously, we can't adjust the federal law, but the two state laws, we reiterate that just because you've used paid leave benefits, whether it's your vacation leave or these benefits or a short-term disability policy, it doesn't extend the amount of job protected leave you have. That's a finite 12-week period.
Right.
And then you can use these as wage replacement during that time. So that's all we're saying here.
So if you use CTO, if you need more time than 12 weeks, whether disability leave or not, I mean, again, this is saying specifically that this benefit is, I mean, again, we could have 24 weeks of any of this, but only 12 of them are going to be protected, provide job protection.
That's right.
Okay.
I've got a question, just, is short-term disability in statute or is it an option?
No, that's an optional insurance policy for your employer.
Thank you.
So some employers provide it, some
Yeah.
don't. Like you heard Commissioner Fastigi yesterday mention that the state doesn't provide a short-term disability policy for employees. So that's the employer's prerogative. And so but some employees have it, and for some employees, it pays generously or provides benefits that they might not get somewhere else. And in some cases, it's partial wage replacement, and this might be preferable depending on how much you make. So there are a lot of calculations that an employee taking these benefits would have to make based on their accrued paid leave, their pre-leave salary. So where they are in terms of the maximum benefit here, and then what other benefits they have. If they have a really good short-term disability policy and they're a high wage earner, so they would be capped out on this, they might choose to take leave with that or their sick leave or something like that. Okay.
The 2056, here we are with the eligibility section. The individual is an employee or an enrolled self-employed individual who earned wages from which the contributions were withheld in 2 of the last 4 calendar quarters. And B, made contributions to the fund on covered work income that was earned during 2 of the last 4, or both. Say someone who's working or not working who qualifies. So again, using just in terms of the stuff that we've talked about with unemployment, if somebody's on unemployment, they can't apply for this, but what if they get injured while they're on unemployment and they can't seek job? Can you just review exactly who is eligible?
So yes, there is no requirement that you are currently employed or currently working in order to qualify under this language. So that's a policy decision, but the current language does not require, so it does say that the individual is an employee, but the definition of employee, let me just make sure on this actually, before so the definition of employee is an individual who receives payments with respect to services performed for an employer from which the employer is required to withhold Vermont income tax pursuant to 32 VSA Chapter 151, Subchapter 4. So there is some ambiguity, I would say, here because it says employee about whether you need to be currently employed. That may be something the committee wants to clarify, whether you need to be employed on the day the leave began or just had to be employed within 2 of the last 4 calendar quarters.
What page did you just look at the
That's the definition of employee is found on pages 4 and 5. Goes from page 4 to page 5, bottom of 4, lines 20 and 21. And then enrolled self-employed individual means a self-employed individual has obtained coverage pursuant to section 2059. There is certainly with an enrolled self-employed individual, there's no requirement that they're currently working in their self-employed capacity. They just have to keep making payments as they earn that income each quarter.
They could be in between gigs. But again, to the next section here, section 2, on page 16, it's just not a different form of unemployment. It's a serious illness. It's caring for a family member with a serious illness or injury, is pregnant, is caring for a new child.
Yep, during the first year following birth or adoption or placement of a for foster care. And you'll notice here, I mentioned this yesterday. I had inadvertently omitted the first year language in the definitions, which is in the existing statute. It is here in the eligibility, but it's probably good to spell it out in the definitions as well. And then taking a bereavement leave is the last piece.
I know it's a policy issue, but I just want to flag again the possibility of adding in rehab from a serious illness or injury.
Please flag that or provide it to us with.
That's under the serious health condition
It is?
flag that we put in yesterday. So
Okay.
not covered currently.
Yeah,
It is
right.
in my flags from yesterday. Sorry. It's been a very long past 36 hours of work, so I'm a little bit
Fried.
fried right now. I'm struggling to complete sentences, so I'll do my best.
And so we will, that's already flagged and we'll discuss that in terms of where does that fit under the category of to me, it sounds like has a serious illness or injury. Sounds like it would fit, but we can work that out next time through. Application for benefits.
Yeah, the last piece here is the disqualification in number 3. That's if you're currently receiving workers' comp or unemployment insurance, you can't receive both at the same time. The point of ambiguity that the chair and I were just discussing about whether you need to be currently employed on the day the leave begins goes to that. It's really a policy question whether you want to let someone who otherwise meets the definition of employee but is receiving unemployment insurance and now is no longer able and available to work because they become injured to claim benefits under this. There is some provision in the unemployment insurance law for them to receive benefits. It gets deeper. I'm just flagging it for discussion later because I know we're on a schedule today. But if that's something you want to pursue, just wanted to flag that.
So now we're to applications.
Yep.
So number one talks about that there's going to be an application with the division.
Mm-hmm.
Two is, and that the employee will make that application. Number two, it's about submitting the documentation of the need for the leave. And that, which is doctor's notes or what have you.
Mm-hmm.
Director shall specify acceptable forms of documentation. Section B on the top of page 17. The division shall review and make their decision within 5 business days. Damien, very quick primer on the difference between 5 days and 5 business days.
So 5 days is 5 calendar days, 5 business days is Monday through Friday, excluding holidays. So
What's our policy? Generally speaking, we have different one. I mean, housing, in landlord tenant law, we have arguments about what's a business day or how long 15 days should be versus 7 days. I mean, those end up being policy decisions in the case of landlord tenant law.
right, so here, typically, we suggest as a best drafting practice to spell out if you intend it to be a business day or a calendar day, to stop those arguments over what's intended ahead of time. And then the length of time is really a policy decision, but this essentially gives a week of turnaround when you have 5 business days. And then the extension is 3 weeks under number 2. So that's the transition.
That's 15 business days, so.
15 business days,
50 calendar days is 2 weeks in a day. 15 business days is fully 3 weeks.
Yes.
Yeah, just this week, just file that away as a thing you'll need to know for the next 2 years.
Yep.
All right, and section 2 is the notwithstanding that would allow the director, if necessary, to take 15 business days. Section C.
So 60 days before or after the leave, you can file. You'll notice I just said days there. The understanding is that this would default to calendar days. Again, you could spell that out if you want to. So I'm seeing nodded heads. Just circle and put in a note.
Thank you.
So that's saying, again, when you know, I mean, I know my doctor's appointments have been at least 2 or 3 months in advance. And so, if you know your pregnancy due date, these are circumstances, at least in some cases, where you're gonna know far enough in advance.
Yeah, so it's worth noting that with the way this is phrased, it implies advance notice to the department for an anticipated leave and notice after the fact if it's unanticipated.
Right.
That's a policy question there. There are different ways to approach that, but that's where the legislature had settled three years ago when they did this, and so that language was just left unchanged in this bill.
So in C, if they file within 60 days after the qualifying event, that would mean they have no income for 60 days. Would payment be retroactive to the date of the qualification?
Yes. Yeah, so the payment is retroactive to the date on which the leave began, and it's actually the lines 17 and 18 shall be paid for the time period beginning on the date
It's right there.
it began. So, yeah.
And then just jumping still right down below that, I'm sorry, so C again, the first half of that clause, the first half of that section is before, when you know beforehand. The second half is when something happens and you're responding to it. So within, again, you may not be disabled or needing to take those 60 days, but you could say, oh, I had to take 2 weeks off because of X within 60 days of the event.
Right.
So that's just, and then, so 2058, it's just, tells us what the time period is when it begins, and then say that the checks would be sent every 2 weeks.
Yeah, I do want to flag something on line 20. Or lines 19 and 20. It says, first payment is sent within 14 days after the individual's claim is approved. Katie McLinn from our office happened to look at this and highlighted something that I had missed, which is, what about an individual who applies 30 days ahead of time before their anticipated leave? Are you going to start paying them before their leave is begun? And so her suggested fix was to say 14 days after the qualified individual's claim is approved or the leave begins, whichever is last occurring.
Sure.
So,
And subsection B is saying that they'll be sent, that the subsequent payments will be bi-weekly.
yep.
Top of page 18.
I've got a question. Would it be possible to put days versus business days in the definitions? So that an individual reading it,
I can just go ahead and clarify anything that's not business days to be a calendar
calendar
day.
day?
Yeah, I'll make a note for just a global edit. So,
So top of page 18 talks about the fact that this will not be, well, this, I have a question about this, about clarity. So this is the article we heard about. This is no garnishing. So the wages were not gonna be garnished, under most circumstances. Damien, on page 28, line 3, if an individual is liable to repay any amount pursuant to this section.
yeah, so,
It's talking about future benefits
those are,
pursuant to this section.
uh,
But is that a different section?
it is just a different section.
Okay.
It is actually, I mean, again, going to belts and suspenders, you could say, except as otherwise provided in section 2063. And then go from there, just to be clear that you don't have a counterclaim to the department or the division saying, well, you know, you fraudulently claimed $2,000 in benefits that we never recovered. And now you're filing again and it's a legitimate claim, but we're gonna hold back the first $2,000
Because of,
because of the prior fraud.
so just, let's provide draft language for that for us, please. That brings us back to page 18. Yes, Jim?
Just a clarification on that, so we're saying that, back where we're at on 18, any creditors that you owe, and child support, anything like that, they can't get their,
Yeah, so this is silent on child support and on unpaid taxes. So in the unemployment insurance law, we provide that the department can recover child support, unpaid taxes, but your creditors, so if you have unpaid credit card bills, or you have a civil judgment against you that's put a lien or a garnishment on your wages, well, housing, landlord tenant, someone who has unpaid rent, the landlord can then seek to garnish their wages and for future income. They can't get that order against these benefits. That's what that's saying. It is silent on the child support. I think you have an argument under this that this might shield you from child support, but I don't know if that would stand up in court. Likewise, under unpaid taxes, I don't know enough just about the law governing how those are recovered. In unemployment insurance, we say explicitly, this is subject to child support recovery and unpaid taxes, but not other liens. This language, the rest of this language is direct from
Okay.
unemployment.
So just flag it, and I would suggest that if we're gonna have this program be able to recoup its own money, I think we should also be able to recoup taxes and child support as well.
Okay. I will flag that and just put in the language and highlight it for the committee.
All right, section D. Just a reminder that the benefits may be subject to income tax. We've talked a lot about that.
And then withholding there.
And withholding. Section 2059 elective coverage, just self-employed. So self-employed individual, we've had a bit of conversation about people coming in and people coming out of the program. That was discussed a lot this week, or discussed some this week. And this is clear in saying that if I'm a self-employed individual, I'm signing essentially a contract with the division for 3 years. As a 3-year, I will pay insurance premiums or payroll tax for 3 years. After which, I will provide my income, which is what B is saying.
Yep.
And any related information. I think the Commissioner of Taxes may have had he made comments about consultation. That section about in consultation with the Commissioner of Taxes. I'm not sure if it was.
Yeah, I think my understanding
That
of,
was DFR saying we don't talk about individual, we don't talk about employees, we talk about businesses.
well, so DFR, DFR's focus is on insurance policies. I think the comment from Commissioner Bolio had to deal with what sort of documentation people are providing on a quarterly basis. But I can look back at my notes from that. I'll just put a note here to look at the notes, and if there is a potential change, I'll add it.
Okay. Top of page 19.
So just to.
Yep.
The 3-year buy-in, initial period, 3 years. Someone may be self-employed, take a job, start another house cleaning business. I assume if someone becomes an employee rather than self-employed, then that 3-year agreement is terminated.
That's the only opt-out from the 3 years is if you become an employee or you move out of the state.
Or collect unemployment, which you couldn't do as self-employed.
Yeah, as self-employed, you don't qualify for unemployment, but that's for the self-employed, the opt-in self-employment coverage. Outside of the 3 years and then annually after that, your only 2 ways out of it are you become an employee and you decide to just take coverage under that, at which point you would opt out. Or you're moving out of the state, so you're not going to be able to take advantage of this coverage anyway. And so you're opting out.
Representative Parsons.
Thanks. I just had a question surrounding how we're dealing with that whole employed, then you become self-employed and vice versa. So as of right now, you're self-employed, not in the program, then switch to being an employee somewhere. You have to wait for your 2 quarters, I would imagine, in order to do it.
Well, the way it's worded is, the way the eligibility is worded is you have to have 2 of the last 4 quarters paid in as either a self-employed individual or employee. It's not really, there isn't clarity in the bill about or there is nothing in the bill that says if I've gone from paying in as a self-employed individual and now I've become an employee, I have to wait another 2 quarters to become eligible.
Okay.
So if I'm reading the bill as in the light that's most favorable to the claimants, I would say that individual should be eligible, provided they've got their 2 quarters paid in.
Right. I'm just, sorry.
But I was gonna say that's a policy question.
Yep. I was curious about that. And then, the other scenario, makes total sense that if you were self-employed, didn't pay into the system, then you become employed and they are paying and you have to wait your 2 quarters to get there. I was thinking of the person who has been employed and then decides to go on their own and says, I'm gonna keep paying in, but now they're starting with their own self-employed program. Do they have to buy in for 3 years and can't start collecting right away? I mean, in theory, they've been paying the whole time and there was no real blip. They've kept paying in and then paid in by themselves.
I think they're the same as with that self-employed individual, just the reverse.
Exactly.
As long as they've got those 2 quarters in the last 4, they should be eligible under the way it's written now.
Okay.
The only thing there is they would have to buy in for that 3-year period, but they can collect anytime they've got those 2 quarters paid in with the way it's written right now.
Okay.
So where this would become a problem is if there were same way that the fund has to build up for 18 months before it starts paying out. If a self-employed person were included in that, needs to pay contributions for a year before being eligible, then we'd need to clarify.
Right, we haven't clarified what to do about self-employed individuals at the outset of the program. Right now, if you're a self-employed individual and wanted to be eligible on October 1, you would enroll to start paying contributions on March 1 of that year instead of paying in for 18 months. So they could get a year less time paying contributions the way the bill is worded right now. That's something you could address any number of different ways. But yeah, right now, if you read the terms of the bill, taxes from employers, payroll tax start being collected 18 months in advance, or 15 months in advance. But self-employed individuals could jump on in March of the year of 2026 and be eligible by October when the program goes live. So,
Which I mean, to me, that's come see, come saw. It's not, I don't see it as a fairness issue per se, but it's, because once October 1st comes along, I mean, in Joe's scenario, if that person goes and becomes a self-employed individual, can say that in the last 4 quarters, I have, because it's tied to your social security number, right? It's not tied to where you worked, it's tied to who you are, and where you worked. And so after 12 months, if there's no income from the self-employed part, then there's a whole other, where is that person working? How are they going to function? But what they owe is definitely covered just because of the 12-month rollover. All right. Thank you. Is there more on that? Because we're at line 5, which is the individual filing claim. It's just a reminder that the benefits may be subject to a tax.
oh, I thought we were already up to page 19.
No?
Yeah.
Oh, maybe I turned back. Sorry.
Yep. Page 19 regarding termination of self-employed individuals.
That's on line 1.
Yep, 30 days before the end of either the initial 3-year period or a subsequent 1-year period. And then, so that's 1 and 2, C1 and 2. And then C3 covers those 2 other scenarios where you become an employee and you decide to terminate your self-employed because you're not going to be earning income that way anymore. Or you stop working in Vermont. I guess the other reason you might terminate your self-employed coverage is because you earn enough as an employee that you're already maxing out benefits, so there's no reason to pay in self-employed. But otherwise, you would be able to count both towards your average weekly wage, so it's really just a question at that point.
Is that what you're saying for D? Is this for D?
This is for C3, the two options, and then D allows you to be both an employee and a self-employed individual at the same time. So. Okay.
Yep. So now the employer 2060 is the employer option private plan.
Yep.
Of course, we heard from, this is just what we're asking, this is what we're proposing for that, going down to line 21, that the benefits have to be equivalent or more generous to the benefits provided pursuant to this chapter. They start to line it out about how they, it has to be the satisfaction of the Commission on Financial Regulation.
Yeah. So the question there really goes back to that line 21, the word equivalent. Your choices are equivalent to or equal to. So the difference is equivalent. We're looking at the scale. Does it balance? Equal, we're looking line by line. Does it check all the boxes? 12 weeks for this at this wage replacement, 2 weeks for that at that wage replacement, et cetera. So there are other requirements in here that it has to meet, but one of them is not, I believe length of leave is not one of them. And so that allows employers to say, I'm providing these lengths of leave, and I think this is equivalent or more generous than the state's lengths of leave over here, and they could vary that across the board. And that's something that a variety of witnesses have talked about, depending from different perspectives in the last few days, but I just wanted to highlight that that's the word that's affecting that testimony about questions about whether this is going to be easy to administer, whether this is going to generate plans that are either easy to obtain or providing actual equivalent coverage. I can't answer those questions for you, but that's the word that question turns on.
And so the main, I think, political question for me is on line 3, is the reference to the Commissioner of Financial Regulation. They made a case for why they're not the right people for this. I think I'd like to just consider possibly just changing that to the division. Whether it's the director of the division or just the division, and just saying that at some point, as the division creates what this organization would be, that they would have somebody who would be able to, I don't know if it's an actuary or regulate, someone with regulator experience, I don't know, but that, because this is a case where we give them a framework of what equivalents are, but I think that there's probably pages and pages of rules that would have to be set in order to judge what that meant. And I think that was the thrust of some of the opposition that DFR has, that they didn't have any ground rules to determine what made it equivalent.
Yeah.
They would need to bring in an actuarial to do
Yeah,
that
so
work anyway.
So if we change this to the division, then it's up to the division to determine whether or not it's equivalent or not.
Yeah, and the division, you could set it up so that the division develops rules and guidelines in consultation with DFR. But DFR is not involved in the administration. And it's worth noting that DFR also had some concerns under ERISA, which is the Employment, Retirement, and Income Security Act at the federal level. I am not an ERISA expert. I think Jen Carby and or Amarin on our staff know a little bit about ERISA, but I do have a meeting with DFR on Monday to get a better sense of what their concerns are on that. And it regulates employer insurance benefits. And I think their concern is about whether we may have areas where we're preempted from regulating. I'm not sure if they exist, but I'm going to meet with them to hear what their concerns are so we can start looking more closely at that to see if there's issues here with this section.
Sure, and so in that section, I'm talking about going from, I guess, the top of page 20 through the rest of the section. Wherever it says the commissioner, I would just, if you could just provide bracketed language that changes that all to the division or the director of the division, just as if we would take DFR out of it altogether,
Yep.
just for something for us to chew on. And that would go through all the way to page 24.
Okay.
And that's just in terms of those names. I think the from a content perspective, going back to page 21, line 11, nothing in this section shall be construed to require the benefits provided by the insurance company, private insurance or benefit plans to be identical. So that's where folks are going to have to determine. Yeah, what DFR was talking about having the ground rules to determine if they're not identical, how is one better than the other?
Right. And so if you change the instances of equivalent to equal to, so that instead of saying equivalent to or more generous, it says equal to or more generous, then what you're looking at is we've got the fixed number that the state law sets, so it has to be that or above, versus equivalent to, where then there's a balancing test, which is that creates ambiguity for the administrators who are trying to determine the policy. So the flip side of that is equivalent to may give flexibility to employers to try to be creative for how they satisfy this. So policy decisions for the committee, but anywhere in that section you see the word equivalent, that's a balancing, versus equal where you're looking for identical or something like that, where it's saying this is a specific number or feature that we're requiring. Does that make sense?
Yeah.
Okay. Are there other things that you want to flag in that section? I did want to.
Thank you. Mine is, after we've all just got done talking about kind of the ambiguity of equivalent, then you get to section 2 there, and there's no ambiguity. It says your private plan shall provide coverage for all employees, costs halfway down 20.
Right, so those are affirmative requirements. But so it says coverage for all employees who'd be covered, cost the same or less, coverage for all forms of leave, wage replacement that's equal to or greater.
There's your equal word.
Impose no additional conditions or restrictions beyond those that are in the law, and then satisfy any additional requirements established by the director. What it doesn't cover, and really the area where there's flexibility here, is length of leave.
Yeah. I was thinking, sorry.
Yeah, no, I'm sorry to interrupt.
I was just thinking that we were talking about how it's kind of doesn't really give them, financial regulation. They're saying that we don't really have the guardrails of how to base it as equivalent or not. It just seems like section 2 is, other than the length of leave, very clear.
Yeah, I think the question is what happens when you have an employer who decides to go more generous on certain features. So say wage replacement ends up at less than 100%, because that equal to or more generous than 100%. I think you're unlikely to see many employers pay people above 100%. But if it went down to, let's just say 70%, then you could see more of this balancing test here. Or if there are certain things that aren't covered and the employer says, well, I'm going to cover those too.
Well, 60%
Yeah,
is 100% of 12 weeks, the equivalent to 60% at 24 weeks. Like,
Yeah.
it's more valuable, the time or the money.
this does require the wage replacement to be equal or greater. So, but what you could see is, for example, shortening bereavement leave and then providing longer military exigency leave or something like that. And that, I think that's what their concern is how do we balance when you start playing with leave lengths and possibly other features of the plan? How are we supposed to balance that, even though they have those affirmative requirements? And I can't speak for them, but I think that was where they were going.
Can we again put the rider in this, or I don't know if it would make it shorter. I mean, we're being pretty specific overall, and would it behoove us to just say that the division will determine what makes equivalence, or is this?
We did that in a previous version, prior year. So there's really kind of a couple things there. Yes, we could do that. One, it opens up questions about whether we've delegated away too much legislative authority. Because we're letting them make the policy. Have we given them enough guidance on the policy? And then the other question or the other issue is, I'm not sure if that makes it more clear for whatever state entity is doing this. They still have to figure out how to make that judgment. And in the past, we said, yeah, just do it through rulemaking and tell people what an equivalent plan is, without any more guidance than that. This one tries to set out more guidance, but still leaves open that gap. And I think their testimony was that they're still concerned about those areas where there's flexibility because they're not sure how to weigh that if something goes lower than say, so if say you diminished length of leave on a couple of things, but you're providing an enhanced benefit somewhere else, is that still equivalent?
And that's
yeah.
so let's just move along. I mean, flag it, and let's just
Yep.
and represent James.
We're coming back to it, so it's fine.
Okay, so these next several paragraphs have to deal with the application by the employer. So 2A, up on page 22, 2A, 2B. And 3 have to do with the application process, timing. I have a question about D, it's line 15.
On page 22?
Page 22.
Yep.
It says, this is in the section about a business applying for a private plan.
Yep.
It says here that the contested determination or denial of benefits under a private plan shall be subject to appeal pursuant to section 2061. So if there's a private plan, they deny me benefits and I want to appeal, am I appealing using the same process that it would be for a state plan?
That's what that provides. It provides that your appeal is to the state rather than through a administrative process with the insurer.
That would supersede a contract that in the case that we're dealing with.
Yeah, so they're operating in a highly regulated field here and subject to the state's laws and regulations allowing them to operate here. So their contracts, you can't contract around the law, essentially. So what they would be doing is if they're offering family and medical leave insurance in Vermont to an employer that's qualifying under this, they need to allow for an appeal to the state, which will supersede their benefits determination. So that's what this is saying. This isn't saying we're going to void an existing insurance contract or require something in an existing insurance contract that would violate that contract. This is saying contract businesses that want to take advantage of this option, their contracts have to allow for a contested determination or denial of benefits to be appealable to the state who would make the final decision. So that's, again, it's a policy decision, but it's not the same as suddenly putting our hands into existing contracts, which you can do, but the conversation is a little bit different if you're interfering with existing contracts and changing the way things work, in the way that I think we've seen, things like bills prohibiting it, arbitration and things like that, which have a whole host of other legal questions, but those are generally prospective from the effective day forward. Clauses like this in a contract shall no longer be effective because we find them to be harmful to the populace or to businesses or to competition, something like that. And that's action under the state's police power, which has it's a different legal conversation than just going in ahead of time and saying, these are the requirements if you want to do this. We're creating a new area here and this is how we're going to regulate it. So.
Thank you. So section E, which goes from the bottom of page 22 through to top of page 24 are the termination provisions, either by the employer or by the commissioner or the director.
Yeah, and I think there were, and I'm hoping to get a little more clarity when I talk to DFR on Monday about their concerns, but I think they had concerns both about terminating a plan, about when they would be aware that any of these violations had occurred because of the way they regulate. So assuming they are the regulator and could be the division. And then the other piece is the number 4 at the bottom of page 23, recouping those monies to the state. I think there were concerns about that, particularly, this is, I believe, when they raised the ERISA concerns. And I don't know if that relates more broadly or just to this language, but I'm looking forward to finding out on Monday when we have a longer discussion on that.
Great.
So I'll
Mark that.
I will mark that, and just when I come back next week, I'll try to include a brief summary of the concerns for the committee to discuss, but you may want to end up having DFR come back in to provide more testimony on that if the committee has time and is keeping this language.
Okay. The top of page 24, the letter F, saying that anybody who is covered by a private plan where the plan is terminated when they go into the state system, they will be considered as already paid in.
Yep. So this, I can't remember whether this was Commissioner Bolio or someone else who highlighted, did not see this language and they were wondering what happened to someone who was covered by a private plan and the plan was terminated, or the employer went out of business. So this covers termination of the private plan. You may want to include what if the employer goes out of business. So it's no fault of the employee's own. They didn't voluntarily quit. They weren't terminated. How are they treated? And this would treat them as if they've been paying contributions to the state all the time. We're silent on the other scenarios where an employee might leave. The understanding, I think, here would be that if you left voluntarily, you'd have to start from scratch in the state plan to develop that eligibility. So. Okay.
So now to 2061, which is the appeals process. And I have a note to myself here on page 25, line 7. All it says is, please explain.
Okay, so, this is more language taken from the unemployment insurance law. And what this means is that when you file an appeal, under this section, any determination that's made during that appeal by, the division or a court hearing an appeal from the appeal, is only binding on the division and the parties to the appeal. It's not binding, conclusive, or admissible in any separate or subsequent action between the individual and any other party that's brought in any other jurisdiction. So what does that mean? So what we're looking at here is essentially if you have an appeal over whether you're eligible for benefits, and there are determinations made in that appeal about whether you have a qualifying condition, or so qualifying condition's a good one because you may have another court case going against your employer about whether you're protected under PFLA, FMLA, whatever job protected leave law. This is basically saying these are separate proceedings and you can't take what happens in this proceeding and use it in that other court proceeding. The reasoning for this under the unemployment insurance law is that oftentimes the unemployment insurance law is looking at very specific things that relate specifically to unemployment insurance. And if you take it out of context, it can create sort of a false light impression that a fact is or is not true when the context is different for different proceedings. In this case, I think, again, that's what this is trying to address is statements that might have been admitted in this proceeding may not be admitted by a court because the judge finds that they're not relevant to the proceeding, they're not probative, they're hearsay, and this is trying to prevent a determination that's made under one set of facts in one proceeding from influencing another court case. So it's a policy decision. It's not something you have to have in there. But it's language that was carried over from the unemployment law just because you have the similar chance for parallel proceedings here where the facts may be, the evidence may be admitted differently for different purposes.
Okay, thank you.
Yeah, thanks. What I heard from that, I don't know if I took it correctly or not. I had to hear that basically a ruling can't be used as precedent.
Yeah, this is not precedent
Not
for
precedent.
anything else, and it's not even admissible evidence.
Right word
Yeah.
for it, but like you can't.
Yeah, so we talk about precedential and persuasive. So it's neither. You can't come in and use it as evidence against a witness or a party and say, well, in this proceeding you said that, or in this proceeding that division over there found that you weren't eligible for benefits. And that could be based on something entirely different that's not actually admissible in the court over there.
Perfect, thank you.
Yeah.
And that's completely different. This is a way of compartmentalizing this particular claim. It's not a de novo, it's not it becomes its own world. And the rest of the world is not part of it.
That's the idea, is to sort of put this into its own box. And then if you have other proceedings outside that, they happen on their own merits. So that's the idea. Like I said, this is not something that you have to have in here. It's a policy decision whether you want to let these facts be admitted.
Well, I
In
think
other cases, I mean,
it
Yeah.
fits right now, but again, we'll give it a higher low sign as we move along, so.
Yep.
So 2062, did you have another question, Joe?
Yeah,
Yeah.
just hopefully quick. And I apologize to everyone else if we just went over this. I was looking some. On 23, where it's the private monies from the insurance company going back,
Yep.
we did that while I was looking something up.
So I think we agreed that I was going to get more information from DFR on their concerns.
Doesn't seem like you can take money back from the insurance company. Okay.
I think there were definite concerns about that.
Okay.
So this was language that we brought over from another state. But again, I am really would like to hear their opinions on that because they're the insurance experts.
Yeah, thank you.
So that makes sense there to make sure that we don't violate ERISA because then the language will be meaningless and there's no point in having language that's preempted under federal law or would potentially put the state in violation, the statute, so.
Okay. Back to 25, line 14, false statement. So when I asked about the difference between an individual and a person, this is the section I was referring to in particular, because line 15, it says an individual who intentionally makes a false statement. Line 18 says, or any other person after notice and opportunity of hearing. And then when you go over to 26, the top of 26 talks about a penalty imposed on a liability by the individual. And then B, a person who intentionally makes, so it goes back and forth, but I just want to make sure that either we're clear that when it's still that in this section, when it says individual, we're talking about a human being. And when we're talking about a person, that person could be a company.
Yep.
And that's, when I was reading it this week, it's just the bouncing back and forth between the two terms. I was confused when I read it.
Yep, so an individual, what we're talking about here, the penalty here is prohibited from receiving benefits. So we're talking about a natural person who has taken a fraudulent action, whether it's to obtain benefits or to help an employer avoid paying contributions owed. That fraudulent action can result in them being barred from receiving benefits for 1 to 3 years. So that's basically what we're looking at here is if you've taken fraudulent action, regardless of which side of the coin it's on, you can be barred from it receiving benefits as an individual. When you go to B, now we're talking about a person. It may be more clear to say an employer in this case. We're talking about, although an employer is any person, but we could say an employer who intentionally makes a false statement. Actually, no, I like person because of self-employed individuals. So let's stay with person. But this is getting more towards liability for unpaid contributions. You're basically making a false statement to hide income or payroll to avoid paying contributions that are due. So that we're doing two different fraudulent activities here. And we're dealing with two different entities. So an employer, in most cases, will not be eligible for benefits unless they're a self-employed individual or they pay themselves as an employee. And in that case, we're requiring them to pay the unpaid contributions, and we're potentially giving them a penalty of up to $5,000 for that fraudulent activity. When it's an individual, whether they've lied on their benefits application or they lied to help their employer avoid paying contributions, they can be barred from benefits for 1 to 3 years. So two different activities. Are there questions on that? Okay. But yeah, that was intentional throughout the differences.
And then we have the numbers here for the full amount of unpaid contributions and the administrative penalty, along with the, how it may be collected.
Yeah, and
And
that's,
this will be deposited into the fund.
yep. And then administrative penalties are penalties imposed by an administrative agency. If the person doesn't pay it willingly, the agency can seek enforcement at the Superior Court. The court at that point can make rulings that maybe the penalty's barred because it wasn't permitted under the statute or something like that. But it basically, if there's dispute over the penalty and the agency wants to pursue it, they've got to go to court to enforce it. That's your prevention from agency abuse of these penalty provisions. It's by requiring it to go to Superior Court.
Okay, section 2063, overpayment of benefits and collection. So an individual who receives benefits, if they're not eligible to, maybe shall be liable to repay the division.
Mm-hmm. Yep, and so this does not require intent. This is non-disclosure or misrepresentation of a material fact. It can include mistake. So that's important before we go on to the next.
Right, so Commissioner Bolio was expressed some concern over the potential of a typographical error resulting in, substantial funds that we are not supposed to collect. If it's 100,000 instead of 1,000, we're not supposed to collect on it.
Yeah, so that is number 2 here. And so Commissioner Bolio's concern was that so if you moved your decimal place or you forgot it on your check, suddenly that $1,000 payment could be $100,000 payment, $100,000 payment. Gotta do that math, it's tough. And so obviously in that case, that's not like a rounding error. That's a significant amount of taxpayer funds that have been paid out mistakenly. And there's no honest mistake when you cash that check for $100,000.
You can afford that.
Yeah. So, I mean,
Gave them the information, that's what they said, man.
I wrote $1,000 on my deposit ticket.
so the alternative here is to basically say the director may waive repayment of the amount. If it was caused by the division's mistake or the unintentional error or omission of another person, or if justice so requires, or I have language to that effect that's basically like, if you've got someone who's in bankruptcy and they owe, $60 from a mistake or $600, you can just waive it at that point. Because it's not a huge amount of money in the grand scheme of things. This came up a lot during the pandemic when the unemployment insurance division, as they were processing the huge volume of applications, made mistakes. And then individuals who had lost their jobs from the pandemic and now are no longer getting unemployment insurance benefits were being told they owed thousands of dollars because the department had made a mistake, and then it had carried through because no one, when you're processing 70,000 claims a week, no one was catching that there were even, I don't know how many that had mistakes, but that no one was catching these mistakes as they went out the door. And people received 26 weeks of benefits with a $50 mistake. That adds up really fast. So that's another option for the language here, and I can just include that in the next draft.
I would like to see that rather than the shall.
Okay.
I just have a question whether it would make any sense. Feel free to say no, it wouldn't. If in that shall we said could choose to in payments up to 5% of the intended. So that would make, if you 10% more, then you wouldn't.
You could say if the amount is less than X and it resulted from the department's mistake or an error or omission, or say if it's less than the maximum benefit for 1 week, something like that. So it goes up with inflation and you don't end up with a ridiculously small amount in 30 years after inflation. you could say something like that. Definitely, and then after that, say may, if justice so requires, or, there's good language for that, I just can't think of it right now. But I can offer that as an alternative too.
Just want to throw a couple in
And
there.
I'll just put a placeholder for the dollar amount for now.
Sure.
Okay,
Generous use of bracketing, please.
yes.
All right, subsection 3 is a process the director shall go through to provide the individual with a notice of the determination and all the way down to the right of appeal. The determination, there's a 3-year statute of limitations, if you will.
Yep.
B1 talks about the individual repaying.
Yep.
Civil action may happen, individual may request that a waiver.
Yep. And that actually has the language, good cause or as the director deems appropriate and just. Is the term phrase I was looking for.
There you go.
So, yeah, and then this, it's a pretty standard language and it gives the director a lot of discretion to determine if it's appropriate under the circumstances.
Okay, so C on 28 is that section, is that the one that needs more language? Except as provided in section 2063 or whatever it was? This is 2063.
Yeah, so the language goes earlier.
Okay.
This is fine as it is. And then the D is just cross-referencing back to the fraud provisions where you'd be barred from benefits or subject to a possible administrative fine. Yeah.
Okay. And then D is just additional, the individual may be,
Yeah, it's just the possibility of an additional penalty if it was intentional fraud.
so 2064 is rulemaking, which is pretty standard, except that I would ask you, Damien, if we're trying to reduce our reliance on things like the Commissioner of Financial Regulation, does it matter that it's the Commissioner of Financial Regulation in consultation with the director, or should it be the director in consultation with?
I would say, given your edits earlier, if we make those edits earlier where the director is reviewing private plans, I would do director in consultation with financial regulation.
Okay.
So I'll just show.
And then letter C is the blanket, the director shall.
Yeah.
Amy, what time do you have to leave?
Oh, gosh, thank you, right now.
Just a minute.
I can be back close to 3. It just depends how quickly my daughter gets out the door of school and I can get her to walk back here.
Sure.
But I'll come back up as soon as I'm back and
Yeah,
working with you.
Committee, we can take 15 minutes.
Okay.
Are you gonna bring her?
Come back and do some chatter that we need to do.
Only if she wants to come. So I'm not gonna force